Mr. Speaker, I don't think there's any argument in this House, sir, that we have a problem in New Zealand with family violence. We have one of the lowest rankings in the OECD, and we have the highest child death rate by maltreatment in the world. I was in the Solomon Islands recently and spent some time with New Zealand police who are serving up there with the Ramsey Regional Assistance Mission. And they go out on patrol with local Solomon Islands police, and the problem, sir, of violence against women and children is particularly acute in the Pacific. And these New Zealand police are up there, and they go out, typically get called out to a domestic violence incident in the suburbs of Honiara, and they said it's very much like what it was like in New Zealand 35 years ago. The courts, the police force don't take domestic violence very seriously. Women getting beaten up in the home is considered to be a domestic and therefore not appropriate for legal intervention. And they were at the same time shocked by the situation there, but also, interestingly, I thought, reflecting on the fact of how far New Zealand has come in the space of a generation on this issue. We have come a long way on this issue. I think in our lifetimes there's been a massive change, but the statistics that colleagues this afternoon have read out in the House, the stories that Sir William Seo recounted, were a reminder of just how shocking the problem is in New Zealand and how far we have to go. And sir, that is why Labor will support this bill. It actually does take us further ahead. It gives more tools to the courts to reduce the harm of family violence, but it doesn't go far enough, and that's the shame of this bill, sir. Labor wishes it was more ambitious, but it's not, sadly. I want to just remind us of the object of the Domestic Violence Act 1995, which is one of the pieces of legislation that this bill seeks to amend. The object of the 1995 Act is to reduce and prevent violence in domestic relationships, recognising that domestic violence in all its forms is unacceptable behaviour, and ensuring that where domestic violence occurs there is effective legal protection for the victims. And I would say, sir, that amongst all the submitters to the Select Committee, to agencies and NGOs and government agencies all around New Zealand and the general public, that the object of the Act, there's an extraordinary degree of consensus behind it, and we should be trying to strengthen the legislation, and it's just a shame that this bill doesn't go far enough. I wanted to talk about Clause 6 in the bill, which is one of the problematic things, and I want to respond to some of the comments that were made by Chester Burrows earlier in this debate. This bill extends protection under the Domestic Violence Act 1995, and it amends Section 16 of that Act, making it clear that a protection order applies for the benefit of a child of an applicant until the age of 17, unless that order is discharged sooner. Now, the Select Committee recommended amending Clause 6, Subclause 2, to provide that the child of the applicant's family would not be required to apply to the court for a direction that the protection order should continue for his or her benefit after the child turns 17, while they continue to ordinarily or periodically reside with the applicant. And the Select Committee was agreed on that point, sir, and it's been reflected in the bill that's come back to the House. Where there is disagreement is whether or not they're saying the provision should apply after the young person leaves the home of the applicant. And it's the view of the Labor and Green members on the committee, I understand, that there should not be a time limit, and that if the young person continues if the young person leaves home, goes off to university or wherever, that the the protection order, as it applies to them, should not automatically expire, and that it should be up to that young person to make their own decision about whether or not they wish to continue to be covered by the protection order. And we heard Chester Burrows say that and typically in that situation, the young person turns 17, they move away, that the need for a protection order dissipates. Well, see, I don't know how the member could know that the need for a protection order dissipates. Shouldn't the young person be allowed to decide, make that decision for themselves? Mr. Burrows said that a 17-year-old is mature enough to make the decision to reinstate the protection order. And so I challenge that view, and I ask the House to put yourself in the shoes of a young man or a young woman who's grown up with a violent and controlling father. Turning 17 or 18 doesn't make you less scared of that person and less vulnerable to control. And I think it puts the young person in an extremely difficult situation to be required by the law, if they want to continue that protection after the 17th birthday, to have to actively make the decision to go to the court and put in place to seek another protection order, to go through the legal process. The law in that case would be putting that young person potentially in grave danger. And if we're serious about the intent of this legislation to give people proper, substantial legal protection from and give young people in this case, the chance to live a life free of fear and violence, then I challenge, sir, the government's judgment on this provision. There are a number of provisions, sir, that are contained in Labor's legislation in the Domestic Violence Reform Bill that, as my colleague Carmel Sepuloni said, has been left really at the bottom of the order paper. A number of provisions that we believe could and should have been included in this law, and it's a missed opportunity. This bill is weaker than it could have been, and as far as we can tell, there's no good reason that these provisions have been omitted. So let me touch on them. One of them is the question of the definition of the child under the legislation in the Domestic Violence Act. Under Labor's bill, we would have raised that from 17 to 18. This would have been consistent with the UN Convention on the Rights of the Child. Currently, under our law, a child only goes up to the age of 17. One of the other provisions, sir, that we think should have been included in this bill is one that would require any judge who declines a so-called without notice application for a protection order to provide written reasons for declining that application. Now, a without notice order is commonly used. It's when a protection order is given against someone who's allegedly been committing acts of violence against the applicant, and it's in situations where it's deemed to be sufficiently the evidence is sufficiently strong, the risk is sufficiently great that order is given without any prior notice or warning to the alleged perpetrator. Now, the problem with this, sir, is that without this kind of provision, what happens is that judges who aren't required to give a written reason for declining the application can then set in train a sequence of events which will put the applicant, usually the woman, at risk again. And if the judge is required to give a reason, that allows the applicant then to engage, to bring more information, to make the case again. And without that, the risk is that sometimes that a sequence of events is set in train that would actually result in a notice being given, and that can put the woman at risk, sir. So we think that that would have been a sound provision. There's no good reason that I can think of or that I've heard that should have been omitted. So, sir, we support this bill. We think that it will strengthen the law in some key areas, but it's just a shame that the government hasn't gone further and been more ambitious.
Paul Quinn.